Okay, so we've now got to the point of setting up the case plan, because whether that's under the single counsel where you've given us a general case inquiry, asking us to set it up, or alternatively where we've granted the authority and those who have made the decision will notify the high cost family team that they've done so that they can set up the case plan task for you. At that point, the case plan task is set up and you'll receive a notification from the high cost family team explaining what you need to do. Now, what you need to do at that point is to return the signed contract to us and to, at the same time, apply for the default cost limitation applicable to the level of representation in the case. So for a single counsel case, that would be £32,500. In a Queen's Counsel or two counsel case, it will be £60,000. So return the signed contract, return and upload the counsel acceptance form, and apply for the cost increase at the same time. Again, Scott, Chris, Rebecca, do you want to come in at all and to talk about anything arising at that point in time? I'm thinking in particular about, again, the need to focus around costs and thinking ahead and planning ahead and that proactive thought process.
I think in single counsel cases, it can be a little bit trickier because cases can run, and that's quite often what becomes the trigger for a single counsel case becoming a very high cost case. It just keeps running. So it can sometimes, the costs can run away with you and you can suddenly go beyond that £32,500 limit without realising. And I think that's where it is key to have constant communication with counsels clerks, because we will be keeping a track of our costs and know where we're up to. So I think whenever there's a significant change to the timetable, if a case runs part heard and goes longer than expected, I think that's the point where you should be, if you haven't heard from clerks, you should be prodding them and saying, what are your up-to-date costs, so we can keep a track of them. And I think in two counsel cases, it's even more important, and Chris will tell you at some length about that.
Yeah, thank you. I'll try and keep it short. No, I think with two counsel cases is actually a little bit easier. Usually we have quite a good idea of what's coming to us in the future. So if we see a matter that's been listed, say, for 15 days, and it's got a QC and junior on it, we know that's going to exceed the £60,000 limitation pretty quickly. I think that's when I believe, from a clerking point of view, you should be proactive. You should be saying, I'll tell you what, I know it's going to be events, I know it's going to be X, Y, and Z. I will send over an idea of what fees are going to be like for junior QC. That will then give a very good bit of information for solicitor about whether or not a plan needs to be done. Even if the case is possibly not going to exceed 60,000, but could come close, it still doesn't hurt for a clerking point of view to just send through an idea what fees are like. I think the bottom line for me as a clerk, and mostly for Scott, well, definitely for both of us, is it's about being proactive. It's about communication, being proactive, not just a one-way street. So I think solicitors, if they want an idea what fees are, even if it's not even close to the 60,000, ask the question. We'll give you the answer, no problem at all, and vice versa. So I think it's much a case of us being proactive as a clerking side, as well as being the solicitors, all the onus on the solicitor. So that's what I would add to it, because it will just make it a lot more easy and a lot more seamless, and we will get paid quicker. So that's where I would come from, which is obviously the end goal. So yeah, I don't know if Rebecca's got anything to add to that from her point of view.
It's pretty much the same thing. I was just going to say that if you are in a situation where your costs are escalating and you feel like they're running away, then don't forget you can always prepare an interim case plan. I think that's a brilliant idea. You can share that with counsel. It will give you a really clear indication of where you're at. And from a drafting point of view, a cost drafting point of view, I'm not sure whether a lot of people know this, but from the way that we charge for interim cases and then topping them up essentially and preparing the final, the fee is not really very different, if at all, between having an interim that we then update compared to having a final at the end. And if you've got the ability to do that, I mean, there's massive benefits in terms of you can POA at 100% of the incurred costs, happy days. And you can also then be ready to get your case updated quickly at the end and get it paid and done. So there's huge benefits there from providers' point of view, but also from chambers.
Rebecca, you've brought us very nicely round to the interim case plan stage. I appreciate that, because essentially we need to be thinking what those costs are before they're incurred, thinking about the number of events that there are, and are the costs in the case going to go above the default cost limitation? Because if they're going to go above the default cost limitation, whether that's £32,500 or £60,000, at that point, there are decisions to be made about access to funds, because you will be limited on payments account to whatever the cost limitation is on the certificate. So if you're going to go above that and decide not to submit an interim case plan, it's going to have an implication as regards your own cash flow, but it will also have implications for council as well, for the reasons that have already been given, that they can't access the funds for payment on account. Now, if the costs in the entire case are going to be less than the default costs on the certificate, then of course there's no need for you to submit an interim case plan. There is absolutely no need. That can wait until the end of the case. But if they are going to exceed, then this consideration needs to be had, and the discussion needs to be had with council's clerk as well around doing that. And it's really important. It's this conversation, this ongoing conversation throughout cases with council's clerks, to keep the case planning process moving smoothly, to aid your cash flow, to aid council's cash flow, so it all comes together. It's where there's a communication breakdown that we often see the problems in the development and process of the case. Chris, Scott, Rebecca, want to come back in again? I don't know whether Chris wants to go first on this one or whether Rebecca comes in.
I'll dive in. Oh, no, go on, Chris. After you.
No, after you, Scott.
Okay. I was going to say that when the joy of high cost cases now through the CCFS system is that if cases are run efficiently, if case plans are run efficiently, then we can all get paid almost straight away for 100% payments on account, which is fantastic compared to the old school fully costed case plans where we'd be waiting sometimes years to get paid. So it's a huge benefit to everybody to be able to run them efficiently. And I think that where it can get really frustrating, especially for us as clerks, is that when cases aren't, and when the interim case plans aren't done, and so the costs aren't being topped up, we get to the position where we're running up tens of thousands of pounds worth of costs for council, and they just can't access funds. They cannot get paid payments on account, which can be financially crippling. I mean, we are talking about self-employed people who have no other source of income. They're not paid a salary, so they rely on getting paid for that work that they do quickly and efficiently. And if you've got 2 or 3 high cost cases running one after the other, it's very easy for all of your funds to be locked up and for you not to be able to access them. So it's one of those things where very recently I had a member of Chambers who had close to £100,000 worth of fees in 2 high cost cases. One was just a long running single council case that kept running, but the solicitor didn't want to do interim case plans because it just kept running and wanted to wait until the end, which meant that we just couldn't get paid, and that was really a really difficult position for her to be in. So it's one of those situations where just by doing the basics around the interim case plan and keeping the costs in check, you can make sure that everybody gets paid and not get constantly chased by council's clerk, which you don't want either. And I suppose, Chris, it's always the case in 2 council cases, isn't it?
Yeah, pretty much, because the costs are so high that you'll never, unless you're, it's very unusual for you to actually have a high cost case for 2 council that is going to be less than 20,000. They're always going to be quite high assets or high earnings, sorry. So I think in that basis, I can't really have much more to what Scott said, because it's basically hits the nail on the head. All I can add to that is exactly what Scott said, is if we communicate, we all get paid, because obviously we want to get paid. We also want to make sure the solicitor gets paid. We can all claim POAs. We can all move forward, and you are the only way we can do that is via the solicitor. We are kind of hands tied, so we'll always do everything we can to assist you. But obviously we need that help from you, because otherwise we're kind of blocked by that point. So all I can do is agree with Scott and say, Rebecca, have you got anything else to add?
No, I completely agree with you. It's about front loading and making sure.
I was just going to add in there that from the LAA's perspective, we do not require any of the supporting documentation with an interim case plan. So the process is very light touch from our end. What we will check for are that the right event rates have been used and the right number of events in terms of what's allowed is there as well. But apart from that, that's it. So I was going to come back to Rebecca at that point and say that how does that compare with your experience?
I think I would spend the time making sure that your case plan, your interim case plan, is correct as much as you can do. There's very little point in preparing something if there's parts of it missing, or if you're not totally sure about the fees. Just spend the extra 20 minutes, whatever it may be, check the rules. The guides are actually really helpful. The legal aid agency guides on CCFS cases, on 2 council cases, they're a really good source of information. So I would just make sure that what you submit, you're confident in. And I'm sure Anthony will go on to talk about some of the rules and things to be aware of shortly.
I was going to dive in there, actually, because I was going to say that when you've done your interim case plan, share it with the clerks, send it to us, because an extra pair of eyes, it's not just checking our own fees, because we make mistakes. We'll provide a cost estimate, which we made a mistake on. I did one just yesterday. I had a 2 council case and I've claimed 2 events for 1 day, which you can't do. And I just hadn't noticed it when I've done it and transposed over from a fee note. So it's very easy to do, but share the case plan with us. We can check it. We can make sure it's correct before it goes to the LAA, at least as far as we can see. And the very same case plan, I noticed the solicitor had claimed for 3 advocates meetings, which they couldn't do either. So those 2 little things, just by sharing that case plan with me, meant that case plan has now not been rejected and will hopefully go through first time.
Yeah,
and worth mentioning that it's part. Sorry, Chris.
No, sorry, I was just going to back onto that. I think I would be surprised if any clerk has a problem with any solicitor sending through an interim case plan or a final case plan for us to actually have a look over it as well, to make sure that everything's in place. So from my point of view, it's just to say, from us being from 2 different chambers, we're both in agreement. We would be more than happy for you to send any case plans over for us to check, to make things a little bit easier.
I was just going to say that it is actually part of the high cost contract requirement that the case plan is shared with council's clerk as well. So it's just reinforcing the message of communication all around, really.
Yeah.
And it's all designed purely to make it flow quicker and simpler for everybody. It's not there as a barrier. It's there as an aid and a help.
Exactly, Anthony. I would say that, and also it saves time, because last thing you want to do is see another case plan where you reject it for the basic reason that there are 2 events on the same day, or you've claimed something you can't claim, or whatever. But it just means that otherwise it slows the process down again, because you have to send it back to us for us then to start it back again and send into you. So I completely agree.
Super.